Today, we're going to talk about workplace discrimination. Both federal and state laws prohibit discrimination on the job and help provide equal employment opportunity for minorities, women, older workers, and people with disabilities. Despite the fact that the laws have been around for many years, workplace discrimination still occurs. Many people still do not get the employment opportunities they deserve on the basis of their skills and abilities simply because of their race, color, national origin, religion, sex, age, or disability. Our organization supports equal opportunity and works hard to comply with workplace discrimination laws. But we can't succeed without your help. You play a very important role in making sure our workplace is free of discrimination. The main objective of this session is to help you better understand the requirements of discrimination laws and the organization's discrimination policy, so that you can help us prevent workplace discrimination. By the time this session is over, you should be able to understand what workplace discrimination is and why it is illegal, recognize the requirements of discrimination laws and the organization's discrimination policy, identify different types of discrimination, and help the organization prevent discrimination in the workplace. Workplace discrimination laws protect people against employment discrimination and provide equal opportunity in the workplace. The laws protect job candidates and employees from discrimination based on race, color, national origin, religion, sex, age, disability, and genetic information. The following federal laws are among the most important workplace discrimination laws. Title VII of the Civil Rights Act of 1964 prohibits workplace discrimination based on race, color, national origin, religion, or sex. The Pregnancy Discrimination Act prohibits discrimination against pregnant employees and job candidates. The Equal Pay Act requires men and women to be paid the same for equal work. The Americans with Disabilities Act prohibits discrimination based on disabilities, and requires employers to accommodate otherwise qualified individuals to help them perform their jobs. The Genetic Information Non-Discrimination Act prohibits discrimination that's based on the genetic information of applicants, employees, or their family members. And the Age Discrimination in Employment Act prohibits discrimination against employees and job candidates 40 years of age and older. Similar state laws also prevent workplace discrimination. Workplace discrimination is illegal for three important reasons. The first is that discrimination is unfair. It treats people differently on the basis of characteristics that have little or nothing to do with their ability to perform a job. Discrimination is also illegal because it denies employment opportunities to qualified individuals. Everyone wants to get ahead and succeed on the job. Why should someone be denied that right because he is African American or Hispanic or Muslim, because she is female, because he has a disability that does not affect his ability to perform the job, or just because she is past a certain age? Furthermore, employment discrimination hurts organizations and everyone who works there, even those who are not discriminated against. That's because discrimination may prevent some of the most talented, skilled, and capable people from getting jobs. And when that happens, everyone suffers. Have you ever been discriminated against, or do you know someone who has? If so, you know the damage discrimination can cause. Workplace discrimination laws prohibit organizations from basing employment decisions on anything other than an individual's qualifications and abilities. This means that employers can't take a person's race, color, national origin, religion, sex, age, or genetic information into account when dealing with employees or job applicants. It also means that disabilities must be accommodated whenever possible. In addition, organizations can't apply different standards, or apply standards differently, to different individuals because of their race, color, national origin, sex, age, disability, or genetic information. Discrimination laws also prohibit any type of workplace harassment of employees in these protected groups. They also prohibit employees from harassing their co-workers. In addition, the laws say that employers can't retaliate against any employee for engaging in protected activities, such as filing discrimination charges or testifying in hearings and court proceedings concerning discrimination charges. Specifically, the laws say that organizations can't discriminate in recruiting, hiring, or pre-employment testing. They can't fire employees just because of their race, color, national origin, religion, sex, age, disability, or genetic information. The law requires that decisions to promote, transfer, lay off, or recall an employee can't be based on the employee's protected characteristics, such as race or sex. Disciplinary action must be based on the organization's policy and the employee's performance or behavior is objectively documented, not on whether the employee is a man or a woman, black or white, Muslim or Christian, Hispanic or European origin, or other protected characteristics. Who gets trained is also an issue. In many cases where workplace discrimination has been found, minority and female employees did not have equal access to training opportunities. Opportunities that often determine job assignments and promotions. Finally, organizations cannot discriminate in pay or benefits because of an employee's race, color, national origin, religion, sex, age, disability, or genetic information. Of course, not everybody gets paid the same, but the differences must be based on objective work-related reasons, not bias. Laws are not the only thing that prohibits workplace discrimination. Our discrimination policy prohibits workplace discrimination and requires professional conduct. Our policy supports equal employment opportunity under the law. It does not tolerate any kind of workplace discrimination for any reason. The policy requires managers, supervisors, and employees to obey the law. It also urges us all to treat others professionally and respectfully. Our policy includes a complaint procedure that allows anyone who feels he or she has been discriminated against or harassed to report the problem to management. All complaints will be taken seriously and investigated. Do not be afraid to report problems. Our policy prohibits retaliation for reporting discrimination or harassment. Anyone who is found to be responsible for illegal workplace discrimination will be disciplined and may even be terminated. This includes employees who engage in harassment of co-workers. Are you familiar with the organization's discrimination policy? Everybody who works here should be. Now let's test your knowledge of discrimination law and policy with a little true or false test. Only minorities and women are protected by discrimination laws. True or false? The correct answer is false. Older workers and people with disabilities are also protected against workplace discrimination. The organization's policy supports equal employment opportunity. True or false? The correct answer is true. The policy prohibits any kind of unlawful discrimination for any reason. You could be terminated for testifying at a discrimination hearing on behalf of a co-worker. True or false? The correct answer is false. Retaliation for exercising rights under the law is prohibited. Harassment is only illegal if a supervisor does it. True or false? The correct answer is false. Employees may not harass co-workers either. Now it's time to ask yourself if you understand the information presented so far. Do you understand what we've said about workplace discrimination laws and what is prohibited under the law? Do you understand the requirements of the organization's discrimination policy? Now let's continue to the next slide and talk about race and color discrimination in the workplace. As you already know, the laws prohibit discrimination against employees and job applicants because of their race or color. As we've said, people can't be refused employment, disciplined, refused promotion, or fired because of race or color. But the law also prohibits employment decisions based on stereotypes and assumptions about the abilities, traits, or performance of individuals because of their race or color. It's also illegal to discriminate against an individual because that person is married to someone of a different race, or associates with people of certain racial groups. In addition, the law prohibits discrimination based on characteristics associated with race, such as skin color, hair texture, or facial features. Harassment based on race or color also violates the law. Racial slurs, derogatory comments, offensive jokes, threats, or other verbal or physical conduct based on a person's race or color constitute illegal harassment. The harassment prohibition applies, as we've said, to employees as well as supervisors and managers. It violates both the law and our policy, and will not be tolerated. It is also illegal to segregate minority employees by physically isolating them from other employees or from customer contact. The law also prohibits assigning primarily minority employees to predominantly minority branches or geographic areas. Requesting pre-employment information that discloses or tends to disclose a person's race is generally prohibited by the law as well, because it could be used illegally in the selection process as a basis for excluding minorities. However, it is legal to request such information if it's needed for a legitimate business purpose, such as affirmative action. With the percentage of ethnic minorities in the workforce growing yearly, national origin discrimination has become a major issue in recent years. No one can be denied employment or employment opportunities because of his or her birthplace, ancestry, or culture. Organizations may not discriminate against individuals because of accents, unless there is a legitimate business reason to do so. For example, an employee with a very heavy accent whose English is very difficult to understand might legally be denied the position as a customer service telephone representative. But such exceptions are rare. It is illegal to discriminate against a person because he or she is married to a member of an ethnic minority, or associates with ethnic minorities. For example, belonging to a particular church or mosque, or participating in ethnic promotion groups. Nor can organizations discriminate against an individual because his or her surname is associated with a particular national origin or ethnic group. Rules requiring employees to speak only English on the job may be allowed if the employer can show that this rule is absolutely necessary for conducting business. For example, an English-only rule could be legitimate if its purpose was to promote employee safety. Just as harassment based on race is illegal, so is harassment based on national origin. The same rules apply to both cases. And, although immigration laws require employers to verify that employees are legally authorized to work in the United States, singling out individuals for employment verification because of their national origin or surname, or because they appear to be foreign violates discrimination laws as well as federal immigration law. Religious discrimination is another important issue today. The law says organizations can't refuse to hire or promote an individual, deny benefits, terminate, or discipline a person because of his or her religion. In addition, the law requires employers to reasonably accommodate the religious practices of employees. We will do what we can to accommodate reasonable requests. The law does allow us to deny accommodations that would cause undue hardship on the organization. Employers can refuse to accommodate an employee's religious beliefs if doing so would create an undue hardship on the employer. Undue hardship might involve such things as additional administrative costs, infringement on other employees' job rights or benefits, impairment of workplace safety, or some other problem. The standard for undue hardship for reasonable accommodation of a worker's religious belief is less stringent than the standard for reasonable accommodation of a worker's disability. The law also says that employees whose religious practices prohibit payment of union dues are not required to pay the dues, but may be required to pay an equal sum to a charitable organization. Common workplace religious accommodations include days off for Sabbath observances, days off for religious holidays, needing to leave work early to avoid traveling on the Sabbath, needing time and a place for prayers during the workday, and dressing or grooming in a particular way for religious reasons. Are you familiar with the organization's policy on religious accommodation? If you think you need some kind of accommodation, speak to your supervisor or human resources. Federal law protects both males and females from discrimination on the basis of sex. Despite considerable gains in recent years, sex-based discrimination lingers. The laws prohibit any type of discrimination in employment based on a person's gender. In other words, employers cannot take a person's sex into account in hiring, promoting, discipline, training, benefits, firing, or any other employment decision. They can't hold female employees to different standards than male employees doing the same job. And they can't pay men more than women for doing the same work. Discrimination laws also prohibit sexual harassment. This includes practices ranging from direct requests by supervisors for sexual favors from employees, to work conditions that create a hostile environment for people of either gender. Employees are prohibited from sexually harassing co-workers as well. The laws say that pregnant employees and job applicants must be treated the same as other people, and cannot be fired or refused employment just because they are pregnant. Finally, men and women must receive equal pay for equal work. The Age Discrimination in Employment Act prohibits workplace discrimination because of a person's age, and is designed to protect older workers. Although only people 40 and older are protected, the intent of the law is to ensure that workers of all ages get the same treatment and opportunities on the job. The Americans with Disabilities Act prohibits discrimination against job applicants and employees with disabilities. Individuals are qualified if they can perform the essential functions of a job, with or without reasonable accommodation. Disabilities covered by the Act are physical or mental impairments that substantially limit one or more major life activities. This means that a person who is unable to walk, or someone who can't see or hear, has a disability under the Act. Other serious medical conditions might also be covered. But minor temporary problems such as the flu or a broken arm are not covered. The law emphasizes a person's ability to perform a job, not the person's disability. The purpose of this law is to provide fair treatment and opportunity to workers with disabilities. Finally, under the law, employers are required to provide reasonable accommodation for applicants and employees' disabilities. This might involve modified work schedules, the workspace rearranged for a wheelchair, modified or special equipment, and so on. The Genetic Information Non-Discrimination Act, or GINA, prohibits employers from requesting genetic information or discriminating against an employee or applicant on the basis of genetic information. The law applies to all public employers, private employers with 15 or more employees, employment agencies, and labor organizations. Under the law, genetic information is defined as information about genetic tests. Whether an individual has undergone genetic testing or counseling, genetic tests of family members, and family medical history. If an employer inadvertently obtains genetic information, the information must be kept confidential, and can't be used to make employment decisions. For example, if an employer finds out that an employee has a family history of heart disease, it can't refuse to promote the employee to a job it believes would be too stressful and might lead to heart-related problems for the employee. Now let's talk briefly about discrimination charges and enforcement of discrimination laws. Employees or job applicants who believe they have been discriminated against can file charges with the Equal Employment Opportunity Commission, or EEOC, the federal agency responsible for enforcing discrimination laws. Individuals can also file charges with the state's CEO agency under the state's laws. An individual can establish a basic presumption of employment discrimination, called a prima facie case, by showing that he or she belongs to a group protected by the law. He or she is qualified for the job he or she applied for or is performing. He or she was denied the job, passed over for promotion, disciplined or terminated, and so forth. And the job was filled by someone from outside the protected group, or that similarly situated employees were not disciplined or fired for similar reasons. The employer then has the opportunity to rebut the charges by claiming a non-discriminatory job-related reason, or business necessity for the decision. For example, that a more qualified person got the job. There are a variety of remedies available under the laws for victims of employment discrimination. For example, a court could issue an injunction, ordering an employer to stop discriminating. A court could require an employer to hire an applicant denied employment, or reinstate an employee who was fired because of discrimination. A court can also tell an employer to give an employee a promotion he or she would have gotten if discrimination had not entered into the employment decision. Courts can also order employers to pay employees back pay, going back to the time of the original discrimination. Back pay is usually ordered in cases in which employees have been terminated or denied promotions and lost pay as a result. A court can also require an employer to pay an employee's attorney's fees if the employee wins a case. Since the passage of the Civil Rights Act of 1991, victims of intentional employment discrimination can also, under some circumstances, collect punitive and compensatory damages. Now let's test your knowledge of the different types of workplace discrimination with a little true or false quiz. Employers can refuse to hire people who may come from countries in which terrorists are believed to operate. True or false? The correct answer is false. If a person has a legal right to work in the United States, their national origin cannot be used as a legitimate reason for refusing employment. Only the disability discrimination law requires reasonable accommodations. True or false? The correct answer is false. The law that prohibits religious discrimination on the job also requires reasonable accommodations. The age discrimination law applies to workers of any age. True or false? The correct answer is false. The law applies only to workers over the age of 40. It's illegal to discriminate against a white worker who is married to a black person. True or false? The correct answer is true. Employers cannot discriminate against a worker because he or she is married to or associates with people of a different race. Do you understand what we've discussed about the different groups that are protected by workplace discrimination laws? Do you understand what we said about discrimination charges, enforcement, and remedies? Understanding this information will help you work with co-workers and management to prevent discrimination on the job. Now let's wind up the session with some specific steps you can take to help prevent workplace discrimination and help create a respectful, fair workplace environment for all. You play a very important role in helping the organization prevent workplace discrimination and comply with discrimination laws. The most important thing you can do is understand and follow our discrimination policy. If we all do that, we won't have any problems. It's also important to recognize each person as an individual and avoid stereotype thinking about co-workers who may be different from you. We ask all employees to treat everyone in the organization with respect and courtesy at all times. We also ask you to be aware of your biases. if any, and try to correct them. Many of us grew up hearing things from family and neighbors that might reflect badly on people of different races, religions, or nationalities. As adults, we need to form our own views and learn to accept everyone in the workplace on an equal basis. If you see or hear co-workers engaging in harassing or discriminatory behavior, tell them to stop. A racist joke, making fun of someone who has a disability, or putting someone down because of his or her ethnic origin or religion violates our policy. And it may also be a violation of the law. Think of other ways you can help prevent workplace discrimination. Here are the main points to remember from this session on preventing workplace discrimination. Workplace discrimination is illegal. It denies employment opportunities to qualified people. Discrimination hurts everyone in the organization, not just those who are discriminated against. Do your part to help prevent workplace discrimination. This concludes the Preventing Workplace Discrimination training session.